Hey everybody, Daniel Gaines here. Coming at you today to make a video to show, for one, what's going on with things, why there's such a delay, but also to expose based on statute, the criminality, what appears to be a felony committed by Judge Antonio Tony Manansala of the Jefferson County Circuit Courthouse in Jefferson County, Missouri. What I'm going to show you is the warrant for my arrest from Judge Manansala. He issued a no-bond warrant citing clear and convincing evidence that I'm a danger to the public at large or another person. Yet, the case record is completely absent any such clear and convincing evidence. I filed requesting the evidence be provided into the record. He reviewed it, but refuses to rule on it until after I'm in jail, and he leaves me sitting for however long he decides to leave me sitting. Now, he's intentionally, and has been, and the case number will be provided so you can go look, he's been refusing to rule on any motions or any documents that I file because he wants to prevent me from being able to appeal anything. Because if I can appeal, he has to then explain to them his reason, his logic, and since he can't, he's just decided I'm not entitled to my right to appeal any of his decisions because he's just not going to make any decisions. Therefore, I can't do anything until after he's left me sitting in jail for a few months, a few years, whatever he decides he wants to do. The lawsuit that is still pending against him, it is Judge Frawley who is presiding over that. Thus far, he refuses to address the warrant, claiming he can't interfere in another judge's court decisions, but the warrant's falsified by the judge, which is fraud before the court. That's part of the lawsuit. It was done in retaliation, and the fact that there's no evidence to support it shows that it's retaliatory in nature and malicious in intent, which is also part of the lawsuit. That's part of the retaliation, is part of the amended complaint, which he still has yet to decide on if he's going to accept or not. This same judge allowed Manansala to respond to the lawsuit almost 6 months out of time. Name me one instance where anybody in the country has been allowed to respond to a freaking lawsuit, caught myself, 6 months out of time. Judge Frawley let Manansala because he's a fellow judge. He claimed I made no attempts at personal service when Missouri law doesn't allow for personal service. However, I did email Manansala asking when he can make himself available for service of process so that way somebody could meet with him to serve him. He refused to respond. He knew the lawsuit stemmed from his actions whilst on the bench, which means the public servant has an obligation to make himself available. He refused, and now he's getting shown special treatment in the law and the rules by a fellow judge who, it appears, is intentionally ignoring the law and direct evidence simply to run cover and protection for a fellow judge, a colleague. That also brings us to the warrant. His refusal to address that is still part of the same. It's his attempt to protect his colleague's criminal wrongdoings. Again, he says he can't overstep another judge from another courtroom, and to that I understand and would agree because that's not how the judicial system works. A higher court can do that, not a like judge. The problem is the allegations of what the warrant are and where they stem from are part of the lawsuit, which gives him direct jurisdiction. It's also being alleged that it's in retaliation, in part for filing the lawsuit, which means this judge would then have an obligation to ensure that the defendant, in this case, the judge, Tony Manansala, he's the defendant, one of the two, the judge has an obligation to ensure that that defendant, during the course of these proceedings, isn't abusing his power or authority or position to retaliate against the plaintiff for filing this suit. And in all those regards, Judge Frawley has thus far failed. I filed a change of judge against Frawley. He denied it. He refused to give reason why it was denied. The funny part is he's going to have to at some point on the record. And his excuse is going to be it wasn't timely filed. I already know what his excuse is going to be. That's all he's got. The problem with that is you allowed both the defendants to respond to the initial lawsuit almost 6 months out of time, when neither one of them filed anything with the, well, Dugan's attorney filed, but she filed it with Rathert, who admitted on court record that he was disqualified from the start of this case because it was a fellow judge in the same courthouse, which means him granting her request to file out of time initially beyond the deadline that he granted, it would have been void, which means it's the same as if nothing had been filed. So as far as the courts and the law have to be concerned, neither one of them filed anything, any documents whatsoever with the courts, and they were both allowed to file a response to the lawsuit. Judge Frawley claimed he would, once they responded and I responded in kind, he would set a hearing, make everybody appear so we can address my request for sanctions and all the other issues. It's been over a month since I requested a hearing date. Still haven't heard anything back. Now, to be fair to Frawley, who I think is corrupt as fuck, extremely compromised to begin with, pardon my language, I'm sorry. I'm trying to keep it clean, as you can tell. I'm human, so I'm going to slip. But Frawley didn't get the documents when it was filed. The clerk informed me, after she caught it, that she sat on it for almost the entirety of the month that it's been filed and didn't realize she hadn't sent it to the judge. Weird, considering I've never had that issue with her before. And this is the one that can result in a judge actually getting in criminal trouble. And not Frawley, Manansala. I'll get to that in a minute because I'm going to show you the state statute that says it's a Class C felony what he did. A Class C felony. However, let me get through the story real quick because we're almost there, but there's a few more important facts that need to be stated. So, thus far, I've been unable to get a hearing to address any of this. I filed a mandamus to remove Manansala from the case, and the mandamus was denied. However, there's a caveat to that. It was a denial because it timed out, not because they reviewed it and found no grounds. It was not reviewed by the state justices. Period. It timed out and was kicked, which means I could refile it, of course. I'm not going to. I'm going to go another route with it. I am going to be filing something, just not with the state Supreme Court right away. But at that point, Manansala's attorney will have to decide if he'll accept service of process for this, or if Manansala would rather have me send someone to his home in Ditmer, because I'm not sending anyone to the courthouse for him to intimidate, harass, retaliate against, or anything else. So it'll be at his home, or through his attorney, where it's either proof that it was sent to his attorney, or it can be on video, that audio and video at his home, so that way no claims, no false claims, no nothing can be made. Okay? Now, how do I know his address? Because I get everybody's address if I'm going to sue them, so that way for purposes of service of process. How do I get their address? Public record. You can use public tax record to find the address of people, including public servants. That's how I get their addresses. I only have them for the purpose of service of process. I have no desire to do anything with them. And in fact, it's not even me who gets their addresses or has their addresses. I don't touch any of that because these people like to make false claims about me. I'm due for a haircut. Sorry, that's why I keep messing with it. But anyway, now, with what I'll be filing, it's to first start the process to expose that it's fraudulent, and then it's supposed to result in criminal action if found to be factual that it is falsified. I also tried to, if you remember whenever the trespass initially went down, because this all stems from the trespass case, the warrant is in the trespass case and everything else, I tried to file a police report against Rachel Montgomery for falsifying a court document. which is a state jail felony. Sheriff's Department, Marshak and Dave Marshak, the sheriff, and Andy Sides, the major, the top guy in IA, refused to allow me to file a police report. Now, I played you the audio recording in the past of Andy Sides making excuses for an officer of his falsifying a court document, acting as the top IA guy at the time he made excuses for it and lied about it to try and conceal and cover it up. Recently, almost a week ago, today is actually last day of the week, I emailed Marshak and Sides, Dave Marshak, the sheriff, and Major Andy Sides, top IA guy, requesting that a detective or an officer call me, left him my phone number, so that way I could file a criminal police report against Antonio Manansala for falsifying a court document. Thus far, they've refused to have anyone reach out to me. And at this point, if they do, it's only going to be because I'm exposing them. What that is selective enforcement of the law. It also allows me a beautiful opportunity that I'm going to seize on. See, both the sheriff and the major are going to be subpoenaed witnesses in the 2 different jury trials I have, if they ever get to happen. Again, the warrant is the reason, but we'll get to it being falsified and everything, and I have no obligation, legal or otherwise, to comply with fraud. That's why I haven't turned myself in yet, because I have no obligation to when it's falsified like it is. He wants me to turn myself in, provide the evidence I've requested. If it's there, I'll gladly go up to your courtroom, let you tell your bailiff to take me into custody, and there we go. Really that simple. Show me the evidence first. It's all I ask. I'll take accountability for my actions. Y'all won't. But anyway, the opportunity I'm presented with is most people who claim there's a lot of corruption in the sheriff's department and everything else in Jefferson County, they have, not all, but a lot of, have criminal records. And those people are easily discredited. The problem they have with this case and me is I have no criminal history. The trespass case is my criminal history. I don't have a felony record. I don't have a violent record. I don't have a drug history, an alcohol history, a bad driving history. None of that. A law-abiding citizen. And I'm claiming corruption. The problem is I also prove it. I don't just say things for the sake of saying them. I show case law. I show legal statute. I show documents. I show direct evidence. I show video, audio recordings. And because I'm not a convicted criminal and don't have an extensive record, I'm more credible when I make these claims. And that's the problem they have. That's why they won't provide the evidence. That's why he won't allow me to get this into court or anything else until after he's let me sit in jail for a while, so that way he can try to circumvent the law while I'm in jail, force me to undergo a mental health eval that they intend to falsify to try and say I'm not mentally stable. Little do they know I'm already several steps ahead of them. I'll get to that whenever it's relevant. Let's just say they're not going to have much success or luck when they claim, well, when they have their people falsify those documents too. Been there, done that. Already have the proof. We'll leave it at that. Should be enough, but we'll leave it at that for now. Anyway, because I don't have the same criminal record or history or anything else, and I have the opportunity to put both Sides and Marshak on the stand in 2 separate trials before a jury, I'm in a perfect position to expose the good old boys network operating in Jefferson County by the sheriff's department, the prosecutor, the state prosecutor, the municipal prosecutor, the municipal court, and the county circuit court. The state court, in other words. And everybody in between, to include the Jefferson County County Council. Yeah, one big old good old boys network, and I'm in the position to expose it all. And I'm going to. This is not hyperbole. This is not me saying something that I can't back up. I'm going to expose it all. After it's been a week, so tomorrow I'll be emailing Sides and Marshak back. After another week, I'll post both the emails so y'all can see that I'm not making any of this up. Now, let's further show I'm not making any of this up, shall we? The moment y'all we'll keep it like this. Warrant for arrest. Failure to appear. Judge Antonio Tony Manansala. My name. My address probably shouldn't be on there, but seeing as it's been made public already, and it's in the documents, ain't much I can do. However, you'd be foolish to come messing around. You don't need to know why. Let's just say it's in your best interest not to. I can post what I can do on the range outside. I can put it outside my door so you can see. But you also have to get around the cameras, the dog that's bigger than me, and everything else in a dead-end area that's essentially a cul-de-sac. Good luck. Anyway, no bond. The court orders defendant is detained pending trial and no bond is allowed. The court finds, based upon clear and convincing evidence, that no combination of non-monetary and monetary conditions will secure the safety of the community or other person. You see the exhibit stamp, but that's the warrant. Now you can zoom in, pause it, and look at all this crap if you wish. But signed by the judge, right? Now, the reason it says Exhibit A, if we go up here, this was filed by me, reviewed the same day it was filed by the judge. There's the case number. Here's what he said. The court will hear this motion below after the defendant is arrested on the warrant and is in custody in the Jefferson County Jail. What is this? Defendant's motion requesting clear and convincing evidence so as to move this matter forward to trial. I'll go slow, but you can pause and read all this. Now, I don't purport to be the greatest legal writer in the world. However, I articulate things exceedingly well, and I'm a bit of an asshole, as you can see in this document. However, I have a First Amendment right, and I'm allowed to call out his judicial corruption, his misconduct. Now, this says it was filed on the 9th, which it was. But it was the judge didn't receive it until the 14th, and I can prove that with email too, and I will. But this even says it wasn't officially filed. It was sent over on the 9th, but they didn't get around filing it until 5 days later on the 14th. It even says that's when it was filed. Same day the judge responded. And again, I'm simply just asking for the evidence. Nothing else. I just want the evidence to justify the warrant. And in that document, that motion, that request, I even state that upon the evidence, I can either set a date to surrender myself, or I can set a date to address the warrant, at which time, if I need to go to jail, I can do so, or the warrant can be addressed, it can be taken care of, and we can proceed and get this matter to trial. It's been 2 years now, and it still ain't even got a freaking trial date set, and the judge is intentionally delaying it. Okay? Now, I told you that according to Missouri statute, it's a crime. Well, 570.095, filing false documents, offense of, elements, penalty, enhancement, restitution when system to log suspected fraudulent documents, procedures. Now, there's several different things it states, but it also states any other document, because I know you're going to focus in on all that section there. Any other document not stated in this subdivision, blah, blah, blah. says Class D felony right there, but it also states all this other crap with other laws that tie into it. Knows it states that a judge, if it's a judge, there's multiple other people, but if it's a judge, it bumps it up to a Class C. Let's see. This might be the wrong statute. Hold on, let me look. No, it isn't. It's the right one. So, according to the law, what he did is a Class C felony. And don't worry, I can tie it into this. It's not difficult to do. There's also other precedents that I can use with that. And there's a few other laws, including federal statutes, official oppression, falsifying documents, criminal deprivation of rights under color of law, criminal conspiracy. The fact that this entire matter is predicated on fraud before the court anyway. There's several other legal statutes that can be used. So, I mean, all in all and overall, it's not looking good for the judge. And now the thing of it is I sent my documents to the judge's attorney, who is in the employ of the state attorney general's office. You know, the highest law enforcement office in the state. And their refusal to even file with the courts about any of this, since it is a felony for the judge to engage in fraud from the bench, the staff member, Kevin Smith, his attorney, of the Attorney General's office, is guilty of misprision of felony. The other attorney, Michelle Stallings, she is guilty of the same because she has direct knowledge of this and refuses to do anything about it whenever they have clear legal and ethical obligations to do so. So there's numerous different issues with this, and there's numerous different elements to it, along with numerous different crimes committed by the numerous different people. And so far, nobody wants to do a damn thing about it. Now, so far, it's literally just the prosecutor's office, the sheriff's department, the courts, Jefferson County courts, to include Victor Mellenbrink, the presiding judge. We got the courts, the prosecutor's office, the sheriff's department, the attorney general's office, and the county council thus far refused to do anything about it. We got a few other things we're going to try, filing-wise. And then, yeah, that's where we're at. And then I'll be going back to the higher courts. But either way, I'm still trying to get Frawley to set this hearing so that way I can address it on the record in his courtroom. Because when he allows the retaliation to be carried out in his courtroom, you know, to protect and facilitate a fellow colleague, he's then just as liable and just as responsible. I've decided I'm not even going to try to remove Frawley. He's a senior judge, not just an administrative judge. He was assigned as a senior judge by the state Supreme Court to this case, which means he was given more authority than Manansala has. Or he has more authority than Manansala does as a senior judge, and he was given the same authority as a senior judge typically would have in their own courthouse, in this courthouse while he's presiding over this matter. They assign him as a senior judge, not an administrative judge, so he's not a light judge, he's a higher judge. He has obligations per the judicial canons. Look it up. Just simple Google search of Missouri's Judicial Code of Conduct. Rule 2 will come up, and that'll be the judicial canons. Read what they say. Canon 2. Read every one of the rules in Canon 2. You don't necessarily have to read the comments, but I would advise. But you at least want to read the canon and the rules. And that'll lay out exactly what I'm saying as factual. That he has an obligation to act and refuses to do so. So, that's where we're at. That's where things stand. And essentially, that's why there's nothing to report, really. It's all the same stuff. Manansala is refusing to do anything because he can't rule on anything, because if he does, then that allows me to file with the higher courts, and he knows that's my intent, so that's why he's intentionally interfering with that. The senior judge has yet to set a hearing or grant my motion requesting a hearing, but to be fair to him, he's only had the filing about a week, so I should hear something this week or next week. If not, then I'll file again. Outside of that, yeah, that's really about all there is to tell. It's really about where everything is. Everything's delayed because Manansala refuses to rule on anything to keep me from being able to appeal. He refuses to address the warrant, provide the evidence for the warrant. So, that's where I have a challenge for anybody who sees this video. You got the case number. It's a trespass case. Same case the warrant's in. Go to casenet.com. Type in that case number. Pull up that case. And see if you can find the clear and convincing evidence that shows I'm a danger to the public at large or another person. And if you're unfamiliar on what the legal standard for clear and convincing is, please look that up first. Because it's not like something that maybe possibly could be taken this way if type of thing. No, it has to be, holy shit, if this guy doesn't go to jail, clearly this person or the public or somebody's going to be harmed because he's allowed to remain free. Now, keep in mind, the citation was issued 2 years ago. Over 2 years ago. Nobody's been harmed. There's been no threats of harm. No allegations of threats of harm. No allegations of harm. Literally no nothing. Told y'all I need a haircut. Bald with long hair, not a good combination. Sorry. Just not, being honest. But, you can't laugh at yourself. Well, you live a miserable life. Anyway. I've searched. I didn't have to search. I know of every document that's been filed, everything that's been filed. Even if you take the cherry-picked emails that both the prosecutor and judge put on record and take them for being the only emails, it still doesn't show anything. However, when you factor in their cherry-picked, and I can prove that they're cherry-picked by providing all the emails, which will happen in due course, then it tells a much different story. However, even the ones that are there still don't even come close to that level. They don't even come close to the level of possibly, or even, what's the lowest legal standard? Reasonable suspicion? They don't even rise to the level of reasonable suspicion. But yet, he says there's clear and convincing evidence. Based on the case record, the judge is the only person who has this evidence.